Today is Tuesday, the 2nd of December 2025. It's now 12 days since Nnamdi Kanu was sentenced to life imprisonment and taken to Sokoto State Prison. In just under 2 weeks, Sokoto has quietly become a kind of political and emotional pilgrimage ground. Lawyers, politicians, traditional and religious leaders, family members and supporters have all been making that journey to see him and to plan the next move. Because behind the prison walls, behind the noise on social media, there is one question that now dominates everything. Can this life sentence survive at the Court of Appeal? Stay with me. Where things stand right now, as we speak, Nnamdi Kanu's legal clock is ticking. From the day of his conviction and sentencing, his team gained 14 days to properly file and register a notice of appeal and supporting documents, and about 90 days in total, roughly 3 months, to fully compile, file, and perfect the substantive appeal with all the detailed arguments, affidavits, and authorities. According to his team, that filing process is not yet fully complete, but he has until around the 4th of December to put finishing touches on key aspects of the appeal paperwork. So, between now and that date, everything is about appeal, appeal, appeal. Meanwhile, in the past few days, we've seen some very visible visits to Sokoto prison. One of the most notable is the governor of Abia State, Alex Orti, who went to see Kanu in prison. That visit is important on several levels. Symbolically, it shows that Kanu's case is not just a private matter, it is political, regional, and national. Personally, it sends a message to Kanu himself that he is not forgotten and that there is still pressure at different levels for a lawful and fair resolution to his case. Strategically, it's reasonable to assume that the visit also involved discussions about the upcoming appeal and the hurdles his team believes they are facing, because according to those close to him, there are powerful interests who do not want this case to get anywhere near a serious appellate review. Why? That takes us into the heart of today's episode. Why some people don't want an appeal. Let's be clear. This is not a small case. Nnamdi Kanu is not an ordinary defendant. He is a separatist leader, a major political figure, and arguably one of the most polarizing personalities in Nigeria today. His supporters, especially in the southeast and in the diaspora, believe his trial has been deeply political from day one. His critics believe he crossed many lines, especially with his broadcast and rhetoric, and must face the full weight of the law. But both sides agree on one thing. Whatever happens at the Court of Appeal will be historic. Now, according to a statement issued by his foreign-based defense support network, sometimes described as the Global Defense Consortium for Mazi Nnamdi Kanu, the conviction delivered by Justice James Omotosho at the Federal High Court in Abuja has some serious legal flaws that they believe cannot survive on appeal. Sahara reporters. This is not a casual argument. They say they have reviewed every word of the judgment, carefully checked it against the Nigerian Constitution, examined relevant Supreme Court decisions, and cross-checked with international legal standards. Their conclusion, in summary, is this. A conviction founded on a law that has been repealed is legally impossible to sustain. Strong words. But what exactly do they mean? The repealed law debate explains simply, to understand this, we have to slow down and break the issue into simple language. Nnamdi Kanu was convicted under the Terrorism Prevention Amendment Act 2013, often shortened to TPA 2013. The Nation newspaper. However, in 2022, Nigeria enacted a new law, the Terrorism Prevention and Prohibition Act 2022, sometimes called TPPA 2022. This newer law repealed the 2013 Act, meaning the old one was replaced by a new framework. The ZordanExaminer.com. Now, here is the controversy. Kanu's defense team and their international partners argue that once a law is repealed, it becomes dead, extinct, and of no legal effect, unless there is a clear saving clause that keeps certain parts alive for ongoing cases. In their view, using a repealed law as the foundation of a conviction is a fatal error. They say, you cannot charge, try, or convict a person under a law that no longer exists in the legal books. They point to classic Supreme Court cases such as Attorney General of Lagos State versus Dosunmu 1989 and Waifo versus Attorney General of Bendel State, where the Supreme Court stressed that when a statute is repealed, it is as if it never existed unless a new law expressly says that certain effects or proceedings should continue. The ZordanExaminer.com. Their argument is simple. If the Terrorism Prevention Act 2013 has been repealed, and if the new 2022 law doesn't properly preserve the old one for continuing trials, then a conviction based on that repealed law should be a nullity. In other words, the entire trial collapses because its legal foundation has disappeared. On the other side, however, we have the position of the trial court and some other legal commentators. They argue that the offenses Kanu was accused of were allegedly committed between 2018 and 2021, a period when the 2013 law was still in force. The Nation newspaper. The 2022 law contains saving clauses, for example, in sections that preserve ongoing investigations and prosecutions, so that cases already filed under the old law can continue and be concluded, even after the new law comes into effect. global.arisplay.com. So you have two big pictures. Defense Consortium view. A repealed law is dead. You cannot build a conviction on a dead law. The trial court acted without jurisdiction. Trial court. Some commentators' view. Yes, the law was repealed, but the offenses happened while it was valid. The new law saves and preserves ongoing cases, so the court still had power to proceed. This is the legal battlefield that now shifts to the Court of Appeal. What the foreign defense team is actually saying. Let's listen more closely to the logic of Kanu's International Defense Consortium, especially the lawyer who spoke publicly, Barrister Christopher Chidera, speaking on behalf of the group, Sahara Reporters. He essentially says, for over 4 decades, the Supreme Court of Nigeria has been consistent. Once a law is repealed, it becomes dead and extinct. That dead law cannot be the source of a valid criminal charge, trial, or conviction unless the new law has a proper saving clause that clearly keeps specific parts alive. They go further to say, a court that applies a repealed law is acting without jurisdiction. Any proceedings conducted under such a repealed law are a nullity, meaning they are void from the beginning. To make it even clearer for non-lawyers, they use everyday examples. You cannot use the 1979 Constitution today to decide the 2025 case. You cannot revive old military decrees that have long been overtaken by newer democratic laws. You cannot run a modern criminal trial under a procedure law that has already been scrapped and replaced. So, they argue, if no judge can resurrect the 1979 Constitution, old military decrees, or outdated criminal procedure laws, then no judge should be able to resurrect the 2013 terrorism law after the 2022 law has come into force. From their perspective, by refusing to properly apply the 2022 Act, by continuing to rely heavily on the 2013 Act, the trial court ignored mandatory legal transitions, contradicted binding Supreme Court authority, and thereby acted without jurisdiction. And in law, once the jurisdiction of a court is successfully challenged, everything done in that court is like a building on quicksand that it sinks. Now, contrast that with those who defend the judgment. They say criminal law does not bend backward. You are charged under the law that existed when you allegedly committed the offense. The 2022 law explicitly saves ongoing cases, meaning that even if the old law is repealed generally, it still remains alive for purposes of prosecutions already in motion. allafrica.com. So you see, this is no longer just an emotional argument. It is a purely legal contest about how to read the Constitution, the Terrorism Acts, and the Supreme Court's own precedents. Beyond the repealed law, other legal and moral questions. And yet, the repealed law controversy is not the only issue that may come up on appeal. Remember, there are at least three other big themes around this case. Extraordinary rendition. In 2021, Kanu was seized in Kenya and brought back to Nigeria in a manner that a Kenyan High Court later declared unlawful and unconstitutional, awarding him compensation and describing his treatment as a violation of his rights. Wikipedia. The Nigerian Court of Appeal once discharged him on the basis of this illegality, but the Supreme Court later reversed that discharge in 2023, allowing the trial to continue while still acknowledging the controversy around the rendition. Wikipedia plus one, the definition of terrorism. Part of the prosecution's case involved Kanu's broadcasts, including inflammatory language, alleged incitement, and alleged instructions regarding explosives and illegal importation of radio equipment. The Nation newspaper critics ask, at what point does speech, even harsh political speech, cross the line into terrorism? Supporters say broadcasting and agitation should be treated as political expression, not terrorism. The court, however, found that certain counts did amount to terrorist acts under the law. The state of Nigeria's institutions. Many Nigerians look at this case as a mirror of the wider system. How professional is the judiciary? How free from political pressure are the courts and security agencies? Are we operating a merit-based system where the best legal minds rise, or do appointments and actions reflect patronage and politics? Supporters of Kanu say the case exposes deep cracks, from security agencies to prosecutors to the bench. Those who support the conviction say the process shows that no one is above the law and that even powerful agitators can be held accountable. Whichever side you lean towards, one thing is clear. This case will be cited in Nigerian law schools and courtrooms for years to come. What the appeal really means. So, what happens now? Over the next days and weeks, Kanu's legal team is expected to file and perfect the notice of appeal, set out detailed grounds challenging the use of the 2013 terrorism law, alleged jurisdictional defects, the treatment of extraterritorial broadcasts, and possibly issues around fair trial rights and the earlier rendition. The Court of Appeal will then be asked to decide questions like, did the trial court have jurisdiction given the repeal of the old terrorism law and the coming into force of the new one? Were the right laws applied in the right way at the right time? Did the judge correctly interpret the saving clauses in the 2022 Act? And more broadly, was this trial conducted in line with the Constitution, past Supreme Court rulings, and international human rights obligations? If the Court of Appeal agrees with the defense consortium that the trial was anchored on a repealed or wrongly applied law, it could set aside the conviction, possibly order a retrial under the proper law, or take other remedies open to it under Nigerian law. If, on the other hand, the Court of Appeal agrees that the savings clauses in the 2022 Act are enough to preserve the trial and that the judge correctly applied them, then the life sentence could be upheld, subject to any further appeal to the Supreme Court. So, the stakes are extremely high. For Nnamdi Kanu, it is about freedom versus spending the rest of his life in prison. For the federal government, it is about defending its handling of a long-running, high-profile security case. For Nigeria's legal system, it is about credibility, consistency, and respect for the rule of law. What this means for ordinary Nigerians, some people may ask, how does this case affect my daily life? I'm just trying to survive. It affects you more than you think. Because if laws can be applied carelessly, politically, or selectively, then no one is truly safe, regardless of whether you support Kanu or not. If courts cannot be trusted to strictly follow the law, then confidence in the system collapses and everything from business to security suffers. If government ignores court orders or manipulates charges, it sets a precedent that can be used tomorrow against any other citizen or group. On the other hand, if courts handle this appeal with integrity, transparency, and courage, if the judgment is well reasoned, grounded in law and evidence, and if all parties, government, defense, and public obey the final decision, then Nigeria quietly takes a step towards a stronger rule of law, even in very emotional and politically sensitive cases. That is why, beyond the name Nnamdi Kanu, this appeal is also a test of the soul of the justice system. What to watch for next? As we move closer to the December 4th filing milestone and deeper into the 90-day appeal window, there are a few things to watch. Will Kanu's team successfully file all necessary appeal documents on time? How will the Court of Appeal respond to the argument that a repealed law cannot sustain a conviction? Will the court lean more toward the dead law principle or towards the savings clause interpretation? And finally, how will this case influence other high-profile trials in Nigeria going forward? We will continue to follow the facts, read the court papers, and bring you calm, detailed analysis without noise, without insults, and without incitement. Because at Truthline Africa, our aim is simple: help you understand what is really going on so you can form your own informed opinion. If you watched up to this point, let me know in the comments. Do you think the Court of Appeal will uphold this conviction or set it aside? And do you believe the repealed law argument is strong enough to overturn a life sentence? Remember to like, share, and subscribe if you find value in this kind of deep dive. Stay informed, stay safe. This is Truthline Africa.